Hello students, welcome to Sitaram tutorial. So in this video, let's start the first topic, Government of National Capital Territory of Delhi Ordinance 2023. So here recently in May month 2023, central government has issued the Government of National Capital Territory of Delhi Ordinance to nullify Delhi government powers over the administrative services. So now let us know what is this ordinance and why this ordinance is issued. So let's know about this. So the ordinance is a temporary law introduced by the state government or the central government without approval of the legislature. So generally, to pass a law, first a bill will be introduced in the parliament, and if the bill is passed by both Lok Sabha and Rajya Sabha, and if president signs on the bill, then that bill will become an act or a law. But for some emergency situations or for immediate public importance, without introducing the bill, the president or the governor of the state legislature passes an ordinance. So it is the ordinance power of the constitution is mentioned under article 123 and 213 of the constitution. So article 123 deals with the power of the president to pass the ordinance during the absence of the parliament sessions, and article 213 states that the power of the governor to pass the ordinance during the absence of state legislature. So here the law passed by the approval of the parliament or the state legislature will be the permanent law, but whereas the ordinance which is passed on a temporary basis is valid only for 6 weeks from the date when the next session will start. So that means if the ordinance is passed now and in the next month if the parliament session begins, then the ordinance will be valid only for the 6 weeks from the starting of the parliament session. So if the parliament session has begun and if the ordinance is agreed by both the houses of the parliament, then that ordinance will become a permanent law. But when the parliament disapproves the ordinance, then it will lapse. So here the other important point to remember is the ordinance can be passed only on the subjects upon which the parliament or the state legislature can pass the law. So for example, president cannot take away any of the fundamental rights passed by passing the ordinance. So governor can also issue ordinance under article 213, but he or she have some limitations. So in the matters which require president's assent, the governor has to refer the ordinance to the president, and if he agree, then the ordinance gets passed. So in the May month of 2023, the central government issued the Government National Capital Territory of Delhi Ordinance to nullify the Delhi government's orders over the administrative services. The topic is Model Prisons Act 2023. So the law which our government follows regarding the prisons is the Prison Act of 1894. So all the rules, regulations, guidelines which are being followed in the prisons are under this law. That is the Prisons Act of 1894. So the prisons and the prisoners come under the state list of the Indian Constitution. So 129 years have been passed away using this same old law for the prisons. So to make changes which match the present societal needs, Model Prisons Act of 2023 was prepared by the Ministry of Home Affairs to replace this Prisons Act of 1894. So in this Model Prisons Act of 2023, some of the proposals are the rules regarding reduction of punishments and releasing the prisoners by suspending the punishment and other bail related rules are proposed, and the rules for vocational training and skill development are proposed, and the new rules for the safety and security of the women prisoners and the usage of new technologies in the prison administration, establishing high security in jails, have been proposed under the Model Prisons Act of 2023 by the Ministry of Home Affairs. The topic is the Shiv Sena case. So recently Supreme Court has given judgment on this case. So this case is regarding the whip. So in Maharashtra there was a rift within Shiv Sena party between Uddhav Thackeray and Eknath Shinde groups and led to the change in the Maharashtra government. So Shinde has become the CM of Maharashtra in July 2022. So there was a dispute regarding whip in this case. So as per the rules, the legislature party has no power to appoint leader and the party whip. So in the Shiv Sena case, the Constitution Bench of Supreme Court found fault with the Speaker of Maharashtra Legislative Assembly for recognizing the whip nominated by Eknath Shinde led groups as chief whip of Shiv Sena. So here whip is the official member of the party whose duty is to make his party members follow the decision taken by his party. So appointing whip is only the power of the political party, not the legislature. Okay, so this affects, so if a legislature appoints a whip, then that is against the 10th schedule, that is anti-defection law. So here Uddhav Thackeray has filed a case regarding the upon the legislature. So because of that case, the Supreme Court has declared that on May 2023 a constitutional bench stated that as per the 10th schedule, that is anti-defection law of the Constitution, the power to appoint a whip and a leader is vested on the political party and not the legislature. The topic is Supreme Court can directly grant divorce to the couples. So Supreme Court has declared that it can directly grant divorce to the couples under Article 142. Article 142 of the Constitution provides a unique power to the Supreme Court to do complete justice between the parties where at times the law or the statute may not provide a remedy. So by using this article, the Supreme Court ruled that it can directly grant divorce to the couples generally under the Hindu Marriage Act of 1955 under the section 13 clause B. After filing the first motion of divorce, the couple have to wait for a minimum of 6 to 18 months before moving to the second motion. So the Supreme Court under this overruling the Hindu Marriage Act as its time period has completed, the Supreme Court has now taken a decision to use its Article 142. So under this, the couple can be granted divorce directly without any extending time period. The topic is district judiciary. So here, district and session judges court is the highest civil and criminal court in the district. As per a record, a district judiciary handled nearly 11 lakh cases, and district judiciary solves most of the cases except confirming the death sentence. So the death sentence of the prisoners is only confirmed by the High Court. So the appointments, postings and promotions of the district judges are made by the governor of the state by consulting with the High Court. So in All India Judges Association versus Union of India case, the Supreme Court has stated that the district judiciary's independence also comes under the part of basic structure. So the Supreme Court has also highlighted some of the points regarding the district judiciary. So they are: the independence of district judiciary is also a part of basic structure of the Constitution, because the district judiciary also upholds the rule of law. That means it ensures the fundamental rights of the people, and the district judiciary implements the fundamental rights of the people. Next point is the district judiciary, that High Court and the Supreme Court, all these three should have an integration in terms of salary, pension, and other service conditions. The third point is the officers of the judiciary should be treated separately from the legislative members, executive members, as per the principle of separation of power. And the fourth point is there should be a uniform designation and service conditions of the district judges all over the country. So these are the 4 points highlighted by the Supreme Court by stating that the independence of district judiciary is a part of the basic structure doctrine. Look at the cluster map over here. The High Court is the highest court in the state. Next, the district and session judges court is the highest court in the district. So it is also the highest civil and the criminal court in the district. Next, the lower court that deals with the civil cases is the subordinate judges court, and the lowest court that deals with the civil cases is the munsif's court. On the other side, the lower court that deals with the criminal cases is the Chief Judicial Magistrates Court, and the lowest court that deals with the criminal cases is the Judicial Magistrates Court. So, in a district, the lowest civil court is Munsif's Court, secondary level civil court is the Subordinate Judges Court, and the lowest criminal court is the Judicial Magistrates Court, and the secondary criminal court is in the district is the Civil Judicial Magistrate Court. So this is about the district judiciary system. The topic is recusal by judges. So recuse means to disqualify oneself as a judge in a particular case. The topic was in news because the former IPS officer Sanjeev Bhatt asked to recuse a judge called Miss M.R. Shah in order to submit additional evidence. So in the year 1990, the IPS officer Sanjeev Bhatt was accused upon a custodial death. Later on, in 1995, he was proved innocent, and that custodial death case was closed. After that, in the year 2002, Gujarat riots have taken place and around 1,000 people have died in the Gujarat riots. The IPS officer Sanjeev Bhatt have all the evidences of causes of Gujarat riots against the Modi. A special investigation team was formed to inquire upon the Gujarat riots. Then the IPS officer Sanjeev Bhatt have submitted all the evidences of Gujarat riots and gave evidences of Modi being involved in the riots. After this, the IPS officer was arrested on a closed case of custodial death case of the year 1990. He was given life imprisonment. He is that IPS officer who have given evidences against the topmost people in the country, and he was given the evidences on Gujarat riots as well. He is Sanjeev Bhatt, the former IPS officer. Now coming to the topic, recuse means to disqualify oneself as a judge in a particular case. So there are two types of recusals. One is automatic recusal, that means when a judge automatically recuses himself, and the other type is when other plea to recuse the judge due to the personal bias or any other reason. So in this case, Sanjeev Bhatt asked to recuse M.R. Shah judge in order to submit additional evidences regarding 1990 custodial death case. And there are two guiding principles of recusal by judges. So those two guiding principles are: one is no person shall be a judge in his own case. So here in his own case, the judge can recuse himself. And the second one is justice must not only be done but must also be seen to be done. It indirectly asks the judges to be ethical and impartial before providing the judges justice. So it tells that the judges should not compromise on impartiality. This statement, that is, that justice must not only be done but must also be seen to be done, was given by the Chief Justice of England, that is Justice Hayward, nearly 100 years ago. The next topic is e-governed state. So e-governance means electronic governance using information and communication technologies like wide area networks, internet, mobile computing, etc. at various levels of the government and at the public sector for providing efficient governance. Paying taxes online, digital land management system, providing educational and agricultural services online, all these are the examples of e-governance. So, Kerala has become the first full-fledged state to provide e-governance services to the people. So, it has introduced Kerala Fiber Optic Network project that gives the citizens the right to access internet. It has introduced e-Sevanam, a single portal for 900 public services to taluk level offices. And the other information is there are four main principles of e-governance. They are people, process, technology and resources. The main goal of e-governance is to reduce cost of governance by reducing paper clutter, staffing cost, etc. and making efficient governance by reducing corruption. On July 1st, 2015, Digital India flagship program was launched with a vision to transform India into a digitally empowered society and knowledge economy. So this is related to overall India, but the first state which has implemented full-fledged e-governance is Kerala. World Press Freedom Index 2023. It was published on World Press Freedom Day on May 3rd, 2023. This index is released by the Paris-based Reporters Without Borders (RSF). So it is one of the leading NGO and it works to protect the freedom of press and promotes freedom of information, and it promotes to be democratic, and it promotes freedom of information as a human right. So the press provides information even about the darkest issues. It gives voice to the voiceless. Press provides public awareness on human rights and on the political issues which are essential to make changes in the government and the private individuals. Reporters Without Border NGO, that is RSF NGO, will provide support, shapes the media and internet standards and challenges the government which try to suppress the press. It releases its report based on 5 indicators. Those 5 indicators are political context, legal framework, economic context, socio-cultural context and safety. Now, out of the 180 countries, India was ranked 161 in the year 2023. In the year 2022, India was ranked 150. In the year 2021 and 2020, India was ranked 142. This report clearly states that there is a crisis in press freedom in India. The freedom of press and protection of journalists who criticize the government with the facts are under threat. As per this report, the top 3 countries which has topped the index are Norway, Ireland and Denmark. Hello students, the topic is internet shutdowns. So on August 4th of 2019, mobile phone networks, internet services, landline connectivity were all shut down in Jammu and Kashmir region because of the revocation of Article 370. So here, upon this act of government, Anuradha Basin, who was the editor of Kashmir Times, the Srinagar edition, argued that internet shutdowns and movement restrictions limited the ability of journalists to travel and to publish, and accordingly she has filed a case. She challenged in the court for the violation of Article 19, which guarantees the right to freedom of expression. So here, based upon the case, The Supreme Court has given some judgments. So some guidelines are also being proposed in this case. So those guidelines are, the first one is, as per the temporary suspension of telecom services rules of 2017, on the grounds of public emergency, telecom services can be shut down temporarily only for up to 15 days, but not for a very long duration. The second point is, internet can be suspended under the suspension rules and it should satisfy the principle of proportionality. The principle of proportionality here means the administrative action should not be more drastic than it is ought to be for obtaining a desired result. So, internet shutdown must satisfy the principle of proportionality and must not extend beyond the necessary duration. And any order suspending the internet under the suspension rules is subject to judicial review. And internet suspension for a very long duration violates the freedom of speech and expression as well as freedom of trade and commerce under Article 19 clause 1 clause A and 19 clause 1 clause G. Thus, the Supreme Court ruled that any indefinite suspension of internet services would be illegal under the Indian law, and the orders for the internet shutdown must satisfy the test of necessity and proportionality. So, Supreme Court has issued a notice seeking the confirmation of the government with respect to its judgment in Anuradha Bhasin's case. Hello students, the topic is narco analysis test. So, here wrestlers in Delhi are protesting for justice against the harassment of women wrestlers. The former Wrestler Federation of India president and the wrestlers challenged each other for a narco analysis test to know the truth. So here we have to learn about the narco analysis test. In this narco analysis test, sodium pentothal, also called as truth serum, is injected into a person's body. As soon as a truth serum is injected, the person loses his self-consciousness and thus speaks up the truth. Generally, this type of test is performed under the guidance and supervision of the psychologist, investigation officer, or under an forensic expert. This narco analysis report cannot be used as a primary evidence in the court, but under section 27 of Evidence Act of 1872, if any information or any material that is discovered through the voluntary narco analysis test report can be submitted to the court as an evidence. So there are other two tests for lie detector. They are the polygraph test and the brain mapping test. So in polygraph test, instruments are used to measure blood pressure, pulse rate, breathing, sweat glands and blood flow, and then they are asked questions. So based upon the answers, they'll measure all these things and they will confirm whether the person is telling the truth or a lie. The next type of lie detector test is brain mapping test. This is also called as P300 test. So brain mapping is done which extracts neuroimages. Neuroimages of the brain can be extracted for analysis and information. So these are the two types of tests of lie detectors, and the other one is the truth serum. So here in Selvi and ORS versus State of Karnataka and ANR case of 2010, the Supreme Court has made few statements regarding the narco analysis, brain mapping and polygraph tests. So it stated that the Supreme Court has stated that these tests cannot be conducted on any person without his or her consent. So without a person's permission, these tests cannot be conducted because it is against the fundamental rights of the individuals under Article 20 Clause 3 and Article 21. So here Article 20 Clause 3 states it is the right against self-incrimination. So under this article, no person accused of an offence shall be compelled to be a witness against himself. So under Article 20 Clause 3, a person cannot provide evidence against himself. And next is Article 21. It is right to life and personal liberty. So this right also includes right against cruel, inhuman or degrading treatment. So this is about the narco analysis test.